Welcome in. This is Ask a Lawyer with Blaine Cluton. I am joined in studio today by Professor Eric Priest as my special guest. And I always start out the top of these shows by saying, I'm an attorney, but I'm not your attorney. And that the information that we provide in these discussions, it's not legal advice. It's a guide or a starting point. And if you have questions at the end of these discussions, I encourage you to contact an attorney for further clarification. The reason I brought Professor Priest on the program is one of the most frequent topic areas that I'm getting on this podcast is about intellectual property. This is not a current practice area of mine. I did study it in law school, and as I was thinking back on my studies, I remembered my professor who taught me a tremendous amount and I thought would just be a really good guest. So, Professor Priest, before we get started, would you please give the audience a little bit of background on yourself?
Sure. Thanks for having me, Blaine. It's an honor to be on your podcast and a lot of fun, so I appreciate it, and it's nice to reconnect with you. So, the way I got into intellectual property was through music. I always loved music, and when I was young, I always knew I wanted to do music. When I grew up, I was a producer and a songwriter for about 10 years, had some success, signed a music publishing deal, had a couple of charted moderate hit songs in Europe, did some work. I also had a strong interest in China and Chinese culture and language. In college, I studied Chinese, and so I also went to Beijing and studied back in the late 90s. And at that time, the music industry there was very nascent. So I had an opportunity to work with really the top regional record label there on some production and doing some talent scouting and that sort of thing. My background was really in the music industry and kind of an international background, US, Europe, and China. But I decided that I wanted to be a lawyer. I was really interested in copyright law, and so I went to law school. I practiced at Dorsey and Whitney, which is a firm based in Minneapolis, where I'm from. So I was in the copyright, trademark, and brand management group. And then I ended up getting hired at University of Oregon, which was great. That was in 2009. So I've been there now for about 13 years.
And at the University of Oregon, where you're teaching, when I was there, you taught a lot of different property classes. You taught property law for 1Ls. You also taught a trademark class, a copyright class, a patent law class. Are those still your areas of focus?
Yeah. So I teach first year property, and then I teach actually 3 upper division intellectual property courses. So I teach copyright law, trademark law, and intellectual property licensing.
Awesome. Well, thank you for joining me. The place that I'd like to start, and this show is really geared toward the non-lawyer, so people asking questions and trying to just get a direction, a starting point. So the first discussion I wanted to talk to you about was trademarks. And the things that I was going to be asking you about are, what is a trademark? What does it protect? What is the difference between a trademark and a copyright? Examples of trademarks. Do trademarks expire? How hard is a trademark to obtain? Registering versus non-registered trademarks. Use of a trademark versus registration. And then about infringement, questions about infringements, how to avoid, how to assess risk. But before we get started with trademarks, I think a good starting point is to understand the difference between an intellectual property. When we're talking about intellectual property, we're not talking about real property. And real property is what most people usually think of when they think of property. They might also think of personal property like a vehicle or something like that. But generally, I think when they think of property, they think of a car. So can you tell us just generally about what is intellectual property and how was this segment created?
Sure. Intellectual property is quite different, obviously, from real property. Well, I shouldn't say obviously, because a lot of people aren't necessarily aware of the differences, hence your question. So tangible property or physical property is something that, based on the fact that it's tangible and physical, there are, of course, rules around the use that govern the use, the exclusivity of tangible property. But it's difficult for someone, say, I can physically exclude you from a piece of personal or tangible property, right? So let's use my cell phone for example. If you want to use my phone, right, I have the right to say no. That's what the right of exclusion is. And unless you're going to come and commit a crime like assault me and physically remove it from me, you're not going to be able to use that phone. What we say is that a piece of physical property is, or tangible property, is physically excludable. And economists also say that it is rivalrous. And what that means is either I have my phone or you have my phone, but we can't both have my phone at the same time, right? It's a rivalrous resource. What that means is that in many ways, it's easier to control than something like an idea or a concept or a work of expression, right? Because again, this is the same with real property. I can physically exclude you from coming onto my land by putting up a fence and patrolling my land, keeping you off, right? And also, my land is rivalrous. You and I can't really possess the land at the same time, at least not in a legal sense. And so there are means for enforcing that kind of exclusionary right that you have that even go beyond the law, right? Whereas with something like an idea, or when we talk about copyright, we talk about expression, or when we talk about trademark law, we talk about symbol or insignia that identifies the source of the goods or services. Those kinds of things are intangible. If I write a song, if I write a melody and I hum it or I play it for you, right? I can't exclude you from that melody. I can't physically exclude you from it. And it's not rivalrous in the sense that when you hear that melody, you can have that same melody in your head. We can both have the same melody in our heads, right? I've heard it described as it's sort of like if I have a cup of water, either you or I could have that cup of water, but not both of us. But if I say a poem, you and I can both have that poem at the same time without diminishing the other's enjoyment of that poem. That's a beautiful thing about information. And that's why you hear people say things like information wants to be free, right? Because it spreads so easily. It can be held and enjoyed by an unlimited number of people at the same time. The problem with that is that information can also be costly to produce. And because it is non-excludable, because once you have my idea or my poem or my song, once you have access to that, once it's in your mind or once you have a copy of it, I can't exclude you physically from accessing that copy, whether, again, it's in your mind or, you have your own physical copy of it. In a digital age, it becomes especially problematic because it can proliferate virtually in an unlimited sense. And so in order to ensure that people who invest in the production of non-tangible information goods, and that can be, again, a novel, it could be a film, it could be a song, it could be a poem. I'll set trademarks aside for a second. I'm really talking here about copyrights because trademarks have a bit of a different provenance and they have a bit of a different function. But in the context of certainly copyright or patents, the idea is the sunk costs to develop this information are high. And in order to ensure that someone can recoup those costs, given that information is so easily transmissible, and once it's out in the marketplace, you can easily be undercut by free riders who, sort of come in after the fact and say, look, now that Blaine has invested in creating a novel, I don't have to invest in creating the novel. I can take a copy of it. Once I have that copy, he can't exclude me from that information, and therefore I'll publish it myself, make it freely available, and I can publish it for less than Blaine can because I didn't have the sunk costs that I have to recoup. And so what essentially we have done is said, we need to give creators a legal right that erects barriers around information, Even though we can't typically put up physical barriers around information the same way we can around, say, your home or your physical property, we can put up legal barriers. And they're, to some extent, meant to do the same thing, although in many ways they're also quite different because they are limited rights. There are lots of holes and limitations. It's kind of a Swiss cheese kind of right. There are lots of different ways in which people can legally access and use an information good that are kind of built into the structure of the law. But that's really the core difference between the two and the reason why we recognize intellectual property rights.
Well, I think that that's a really good explanation about intellectual property and just generally understanding the difference between real property and intellectual property. So from here, you've talked about this distinction now between trademark and copyright a bit. So that answers that question. Circling back to trademarks, if I remember from my class, and please correct me, it's been over a decade at this point, but when we're talking about trademarks in general, my recollection is that what we're generally talking about is businesses and protecting business marks. So when we're thinking about that, what a trademark would protect are things like the name of a business, the logo they're using, the slogan they're using, the color that they might be trying to protect, a sound or a shape.
Yeah.
And those are, from my recollection, those are the main things. So name is fairly obvious. Logo, I would think of something like the Apple logo or the Ford or the Chevy badge. A slogan would be something like, "What can brown do for you?" Color would be like the Coke red or the Honda blue. Sound would be like the Netflix sound at the beginning before they play a show. And then shape would be something like a Coke bottle. And those would be all subject to independent trademarks. Do I have that right?
Yeah, that's exactly right. In fact, the U.S. Supreme Court has said that almost anything at all that is capable of carrying meaning as a symbol or a device can function as a trademark. And the idea, right, is that a trademark is really anything, virtually anything. I think there are limits and courts have found limits on what can function as a trademark, but they're relatively few. And what the trademark does, and the key for understanding what a trademark is that it provides a distinction or the ability to distinguish the goods of one provider from those of another. And that's what trademarks do. They allow consumers to distinguish the goods of one provider from those of another. And therefore, what trademarks are is they're the indicia, the indicators of the source of a product.
So the thing that we were going to talk about first was, how does a trademark actually provide protection? Before we get into that, the question was, how hard is a trademark to obtain?
Okay. Yeah. So it's not especially hard to obtain if you meet a few basic requirements. The first is that the mark has to be capable of distinguishing your goods and services from those of another. You also have to be using the mark in commerce. And if you meet those requirements, that the mark is distinctive, in other words, capable of distinguishing your goods or services from those of another, and the mark is being used in commerce, then generally you'll be able to register the mark. You'll be able to protect the mark. Maybe we can talk in a moment about the difference between protecting a mark and registering a mark, because in fact, you don't have to register your mark in order to protect it. Now, there's a third requirement for ensuring that your mark is protectable, and that is that it can't be confusingly similar. In other words, that consumers wouldn't confuse your mark with the mark of another that's already in use.
Okay, and then you said that we'd circle back to protecting versus registering.
Yeah, so trademarks are different from patents, for example, in that there's such a thing as a common law trademark. Really, the way that you acquire rights in a mark is that so long as your mark is distinctive, once you start using it in commerce, you begin acquiring rights in it. You don't have to formally register it in order to claim rights or acquire rights. You just have to be using the mark in commerce. So you can actually enforce your trademark in court, even if it's not registered. But there are significant benefits to registration, especially if you're talking about federal registration, because in fact, there are also state registrations available, but they don't confer the level of benefits that you get from federal registration. So, typically the advice with regard to protecting marks is that really anyone who is using a mark in their business should seek a federal registration because, again, it's not a terribly onerous standard to get registration. It's not nearly as expensive as filing a patent application, for example. And it confers significant benefits, including federal registrations, confers significant benefits, including nationwide priority, which effectively gives the registrant of the mark priority rights in that mark throughout the United States, which is very, very powerful because it, in effect, helps you kind of occupy the entire field, as it were, in the United States with respect to that mark, and also puts potential future users of a confusingly similar mark on notice of your use. So it's a federal registration, and it also confers a number of other benefits, but it's a very powerful tool in the trademark owner's toolkit.
So do trademarks expire is one question, and then the other is, if I register my mark through the federal registration process, what is being protected?
Trademarks do not expire so long as you continue to use them. Well, the registration itself doesn't really protect anything. It's the fact that you are using the mark automatically confers protection, against confusingly similar uses. What the registration does is it kind of soups up those protections. It provides you with, as I said, constructive nationwide priority. It provides prima facie evidence. In other words, you go into court with the presumption that you are the owner of the mark and that the mark is valid. That's actually a very powerful presumption. So there are lots of better remedies, damages that can be obtained, that sort of thing, through federal registration. So registration confers lots of benefits, but it's in fact the question of whether or not, and I guess this gets to your question about infringement, the standard for infringement is a likelihood of confusion. So let's say somebody else's mark is likely to be confused with your mark. That will result in infringement liability, unless there's some other defense that they can raise. But that's the standard for infringement, is a likelihood of confusion. The court will look at it and basically look at a whole host of factors and ask, how similar are the marks? Are you operating in the same or similar industries, right? That would be more likely to lead to consumer confusion if the marks are very similar. If you're operating in similar industries, they'll also look at to what extent are you, the trademark owner, likely to move into the defendant's industry. And again, from the perception of consumers, right? So looking at if you produce clothing and the defendant is in the music industry, how likely is it that a clothing company would move into the music industry or the entertainment industry? They'll sort of look at all these questions to make a determination about whether there's infringement.
There's a thing that exists where you can buy an expired domain and use the Wayback Machine and go back and look what used to be on the website. And you can rebuild it either using some of the same material, so long as you're not infringing on their copyright, but then reformatting using the same URL essentially to create a new website. Now that new website could be an informational kind of an affiliate site where they're selling products through to Amazon, or it could be its own standalone drop shipping kind of a site. But in either case, you have one company that's allowed their domain to expire. The new person has come in and purchased this expired domain. The question is, that name that's actually in the URL could still be the business's name, that they're still operating somewhere. Is there a point at which that name could be abandoned because they haven't renewed the URL? How would a person be looking at infringement in that kind of a case? How would they be investigating to make sure that it's not infringement, or whether we have that likelihood of confusion? And at what point should that person be talking to an attorney?
So first of all, if you register a URL that has someone else's trademark in it, then there are various means that the trademark owner can use to effectively have that registration transferred to them. So it can be a violation of their trademark rights to register a URL that has their mark in it. Now, the important thing to understand is that the use of a trademark is different from the use of a URL, right? So if for whatever reason, this would never happen, but if Nike stopped using Nike.com, that doesn't mean that the trademark becomes available, right? Because Nike would still be using the word mark Nike widely in commerce. And so if for whatever reason they abandoned the domain name and then another individual saw that that domain name was available and registered it, Nike could have that domain name essentially seized from that individual and transferred to Nike. So it wouldn't constitute some kind of an abandonment of the trademark just to cease to use a domain name with the trademark in it. And I guess a more realistic scenario is, what if you have a company that just hasn't registered certain domain names, right? So you have a company, Tracktown Pizzas, one here in Eugene, and they probably have trackdownpizza.com. But let's say they haven't registered tracktownpizza.org or, tracktownpizza.us. If someone were to then register those, well, first of all, let's just say the failure to register those does not impact Tracktown Pizza's rights in its Tracktown Pizza mark at all. And you wouldn't be very successful registering those. I mean, you could register those domain names, but if Tracktown Pizza took issue with that, they could fairly easily have your registrations canceled and have it transferred to them.
Okay. Well, I think that answers all of the questions in the trademarks. And if you'd be willing, I'd love to have you back on for a discussion on copyrights. Are you available to do that?
Absolutely.
All right. So what we talked about for the trademarks was, what is a trademark? We talked about examples. What does it protect? What's the difference between a trademark and a copyright? We talked about examples of trademarks, whether they expire, how hard is it to obtain a trademark, registration versus non-registered, and then we talked about infringement. Thank you, Professor Eric Priest, for joining me on Ask a Lawyer.
Thank you. It's my pleasure.
Until next time, this session is adjourned.